5, 4, 3, 2, 1. Start. Honorable members of the court, today I rise to present my submissions on the matter placed before this bench. The case in question brings forth essential issues relating to the administration of justice, the rights of citizens, and the duties of public authorities. It is our solemn duty to uphold the values of fairness, impartiality, and equity in every proceeding that comes before this forum. The facts of the case, as recorded in the documents filed, must be examined with due diligence and care, without any influence or bias of any nature whatsoever. At the heart of the matter lies a petition filed by the aggrieved party seeking appropriate relief from this court. The petitioner has alleged that procedural irregularities were committed during the hearing of the matter at the subordinate level. These allegations include delay in the service of notice, lack of opportunity for proper representation, and failure to consider material evidence placed on record. It is contended that such errors have caused serious prejudice to the rights of the petitioner, who seeks remedy in accordance with the law. The counsel for the petitioner has drawn attention to several judicial pronouncements which emphasize the principles of natural justice. It has been submitted that no individual should be condemned without being heard, and that justice must not only be done but must also be seen to be done. In light of these principles, the petitioner prays for quashing of the impugned order and for a direction to conduct a fresh hearing in a fair and transparent manner. On the other hand, the respondent authority, through its learned counsel, has opposed the petition and submitted that the proceedings were conducted strictly in accordance with law. It is further contended that the petitioner was given sufficient opportunity to present their case and that there has been no violation of procedure or denial of rights. The respondent has also placed on record certain documents in support of its stand and has urged this court to dismiss the petition as being devoid of merit. After hearing both sides, this court is of the view that a careful examination of the records is required before arriving at a conclusion. The importance of procedural fairness in administrative and quasi-judicial actions cannot be overstated. Every individual is entitled to receive notice and be given a reasonable opportunity to present their case. The law mandates that authorities must act without malice, with an open mind, and must record reasons for their decisions in a manner that reflects objectivity and clarity. In the present case, it appears that certain aspects were either overlooked or not addressed in the detailed manner required. The failure to record reasons for rejecting specific submissions by the petitioner raises doubt about the transparency of the decision-making process. Moreover, the absence of a detailed reply to certain documents submitted by the petitioner has led to an incomplete appreciation of the facts and circumstances. In such a situation, it becomes necessary to direct a fresh consideration of the matter to ensure justice is served in both letter and spirit. It is pertinent to mention that this court is not inclined to delve into disputed questions of fact at this stage. The objective is not to adjudicate upon the correctness of the claims made by either party but to ascertain whether the process adopted by the authority was consistent with the principles of law and justice. If the process is found to be flawed or irregular, it is well within the powers of this court to intervene and set aside the decision so that the matter can be examined afresh by the competent authority. The record reveals that the petitioner made repeated attempts to seek clarity on the status of the proceedings and to present relevant documents. The replies provided by the authority were either delayed or lacking in substance. This conduct, whether intentional or inadvertent, casts a shadow over the fairness of the proceedings. Therefore, to restore faith in the system and to afford the petitioner an equal opportunity to be heard, this court is of the view that the matter must be remanded back to the concerned authority. Accordingly, the impugned order is set aside and the matter is remanded for a fresh hearing. The authority concerned is directed to issue a notice to the petitioner, grant adequate time to respond, and to consider all documents and submissions afresh before passing a speaking order. The said order must contain detailed reasons reflecting application of mind and must be communicated to all concerned parties within a reasonable period. It is also directed that all parties shall cooperate with the proceedings and shall not seek undue adjournments. The petitioner shall file all relevant documents and written submissions within the stipulated time, and the authority shall conclude the process in accordance with law. Any deviation from this timeline shall be brought to the notice of this court through appropriate application. Before parting with the order, this court wishes to reiterate the importance of procedural integrity in all administrative actions. Justice is not a product of outcome alone, but also of the process followed. When that process is compromised, even the best of outcomes becomes suspect in the eyes of the public. A system that aspires to serve its citizens must ensure that every decision is taken with due care, supported by reason, and free from arbitrariness. The principles of justice require not only adherence to law but also sensitivity to the concerns of those affected. Timely communication, reasoned decisions, and impartial hearings build trust in institutions. Authorities must strive to maintain public confidence by acting fairly, transparently, and within the bounds of their legal mandate. Every action taken by an authority must reflect accountability and fairness. This ensures that justice is both delivered and perceived rightly. Let a copy of this order be forwarded to the authority concerned for compliance. All pending applications, if any, stand disposed of. No order as to costs. The matter stands closed. Stop.